Hello, everybody. Thank you again for all those that are attending. It's great to see a very large number of people joining us, and all are welcome. This is one of FTB's afternoon webinars, and there's a series of them, and we ask you to check the website for further details. But on a fairly regular basis, we're going to be providing webinars on a range of topics. The format is quite informal. There'll be one or two of us, as there is today, and we will select a topic and seek to inform, if not entertain. Today's topic is dealing and focusing on heritage matters. Melissa Murphy, who I hope you can see and I hope you'll be able to hear soon as well, she's going to speak first, and she's going to talk about heritage in the context of decision making, with a particular focus on the tilted balance in the framework. And then I'm going to follow that with some slides dealing with a recent Court of Appeal case and some updates in terms of policies and consultations. For those of you that have attended before, you will know that we are able to provide the slides after the event, and we will do that. If there are any questions or any difficulties in that provision, please get in touch with Chambers. I believe also that the webinar may become available on YouTube. The only other thing to say is that we will possibly have time for some questions at the end, but we will finish at 3 o'clock, whatever, so as to enable everybody to get back to their daily business and their work. So I think that's all, isn't it, Melissa? If it is, without more ado, I'm going to hand over to Melissa, who I'm sure is known to many of you, if not all of you, and has considerable experience in terms of the application of policy in heritage cases. Thanks, Melissa.
Thank you very much indeed, Craig. And I'm going to start by sharing my screen with you, so that hopefully you'll have some slides up. How are we doing? I'm going to check my WhatsApp to make sure that I'm told it's good. So we have it. As Craig said, our webinar this afternoon concerns planning and the historic environment. My section concerns, as Craig indicated, decision-making in heritage cases. And Craig's going to provide you with a roundup of what's new in this area, what's new in this area since the beginning of 2001, I think. So by way of a contents list, first we're going to tackle the quite tricky subject of the tilted balance in national policy, to make sense of how heritage considerations fit in with that planning decision-making. And second, a distinct but linked point about a very common formulation of heritage policies and local plans, in particular, the potential for policies being treated as out of date or given less weight, and the current thinking on those matters. And finally, we're going to look very briefly at a recent first instance decision. No talk on this subject would be complete without a salutary lesson in relation to officer reports, and it is that. If you think all this looks rather difficult to swallow, I'm going to offer you a spoonful of sugar to help it go down. You should have on this slide, if you can see it, I hope you can, 4 pictures of buildings. And during the course of the webinar, I'm going to mention each of them in the context of particular decided cases, or one, a forthcoming case. If you look closely, you'll see, I hope, that I've labelled them A, B, C, and D. And your challenge, without Googling, it's no fun if you cheat, is to 3 things. Firstly, See if you can find the odd one out. Secondly, rank them in order of importance, so most important down to least important. And I'm going to use the Historic England listing descriptions as definitive on this point. And then your third challenge, should you choose to accept it, is to identify the principal era in which you think they were constructed. So odd one out, most to least important, and then third, the principal era in which you think they were constructed. If you want to misappropriate the questions box, then do feel free to do so. It's honour and glory alone, I'm afraid, no champagne to the winner. But I think we'll try and mention the first participant to provide the 3 correct answers. I'll drop in clues if I remember to, but hopefully not the answers as I go. Right, you could just say no though, because I know it's hard to believe, but some of us are not competitive, so you don't need to participate if you don't want to. Before we just get into the detail of how the tilted balance operates, Monkhill, in very broadest overview, it's a very recent Court of Appeal case. Judgment was handed down last month. The senior president of tribunal, Sir Keith Lindblom, gave a judgment with which the other members of the court agreed. The case concerned the development of housing on land at Longdean, on Hedgehog Lane in Hazelmere, and it affected the Surrey Hills area of outstanding natural beauty. We're looking at it because it gives us detailed guidance in relation to the tilted balance within paragraph 11 of the National Planning Policy Framework. And also because the court, as the court itself indicated, the conclusions reached can be translated to national heritage policies. So there's various abbreviations used. Most of them will be familiar, I think, to all or most of you anyway. National Planning Policy Framework, paragraph 11. We know too that it is a material consideration within the context of section 70 of the 1990 Act and section 38(6) of the 2004 Act. It does not, it cannot, of course, displace the statutory decision-making, the statutory development plan in planning decision-making. On many occasions since the National Planning Policy Framework was published, originally in 2012, of course, its provisions have been considered by the courts. Indeed, in Monk's Hill, it was observed that since the Planning Court was established in 2014, such cases have formed a large part of its work. And the tilted balance has been a particular focus. And that's because it matters. If you look at the slide, you can see why decisions should apply a presumption in favour of sustainable development. I paraphrase, for decision taking, this means D, granting planning permission unless, i.e. tilting the balance in favour of granting planning permission unless, and then little Roman 1 is what the court was concerned with in Monk's Hill, the application of policies in the framework that protect areas or assets of particular importance provides a clear reason for refusing the development proposed. And you see there a reference to footnote 6. We're going to look at the footnotes in a moment. It's important before we do that to note their relevance. Footnote 7, if you look FN 7, relates to when policies might be out of date. Footnote 6 relates to where policies might provide a clear reason for refusing the development proposed. Okay. And here you have the footnotes 6 and 7. And you'll see that footnote 6, as I've indicated, relates to the application of policies providing clear reasons for refusing planning permission. And that includes, I've put the text in bold here, policies relating to AO and Bs, as in Monkhill, and in relation to designated heritage assets. Footnote 7 relating to out of date includes, i.e. that wording is non-exclusive. Come back to those. So in Monkhill, in that case, paragraph 11D of the framework was engaged because there was a shortfall in the 5-year housing land supply in the council's administrative area. And as you've seen, that's one situation under footnote 7, where the most important policies for determining the application are deemed to be out of date. The key question was whether the AONB policy was one which would, in effect, disapply the tilted balance. I'm just going to pause for a moment so that we can reflect on the wording in 172 of the framework set out here on the slide. Great weight should be given to conserving and enhancing the landscape and scenic beauty. So the question, can the application of that policy result in a clear reason for refusing planning permission? Well, in short, whereas here, Monkhill, the development conflicted with the policy objective, it could provide a clear reason for refusing planning permission within the terms of 11D. And here you have paragraph 28 in the Court of Appeal's judgment. The sense of the word provides in paragraph 11D is that the application of the policy in question yields a clear reason for refusal in the decision maker's view as a matter of planning judgment. See the High Court's decision as to Justice Holgate. And the court did not accept that a policy when applied can only provide a clear reason for refusal if it includes its own self-contained criteria or test, failure of which will be or will normally be fatal to the proposal. And that's not, it said, what 11D says, and it's not to be inferred from the policy, and nor is there any indication in footnote 6 that that's what the government intended. Come to heritage in a moment, but on the tilted balance generally, for the enthusiast, see the court's judgment at paragraph 18, in which there were no fewer than 15 points on the application of the tilted balance, which were matters of common ground between the parties, and the court said, rightly so. So that indicates pretty clearly, I hope, that the case is of general interest in that it provides detailed guidance as to the application of the tilted balance. So you may have been thinking about its applicability in the parallel context of heritage planning. And if you did, then your thinking is aligned with that of the Court of Appeal. I put out here on the slide, for convenience really, 194 and 196 of the framework in chapter 16, dealing obviously with conservation of historic environment. 194, clear and convincing justification for harm, any harm to or loss of the significance of a designated heritage asset should require clear and convincing justification. And then 196, this balance, important, less than substantial harm, it should be weighed against the public benefits of the proposal, including, where appropriate, securing its optimum viable use. So the High Court thought that there was a parallel between the 172 AONB policy within the framework and 196, and said so, as did the Court of Appeal. Now, the application of heritage policies can disapply the tilted balance. Question, why? Well, because the judgment says so, but it's inherent in the policy that if the harm to the heritage asset is not outweighed, then there may be clear reason for refusing planning permission. Just thinking in terms about the mechanism of 11D, once that presumption in favour has been disapplied because there's a clear reason for refusing planning permission, that then necessitates taking into account all of the other factors in the ordinary way, but without applying the tilted balance. That much is clear from the High Court decision in Monkhill, and as was confirmed by the Court of Appeal. So that's quite an important, if you like, mechanical point about decision making, but also substantive. So that's one reason why, because the Court of Appeal indicated that was so, albeit in the AONB context. But also within the four corners of the framework, conservation of the historic environment is an aspect, isn't it? NPPF says so, of sustainable development. But I think more widely, if the opposite conclusion was reached and that the application of heritage policies were incapable of disapplying the tilted balance, well, that would, I would suggest, risk undermining 30 years of relatively consistent national policy. And so it would be odd if it was otherwise. So we're coming now to the second aspect of the talk, but a linked point, because you'll remember that within footnote 7, one reason why policies might be out of date is a result of a 5-year housing land supply shortfall. And I noted that the language wasn't exclusive. Another reason that might be contended, and I know has been contended in cases, is because perhaps the policies themselves don't reflect the wording of the NPPF, or maybe more pertinently, its precise formulation. In Bloor, it was said that an aspect of whether something is up to or out of date is whether it has been overtaken, for example, by change in policy, or perhaps, as I've suggested, in the formulation of policy. Please note that 11D is not necessarily engaged if only one policy is out of date. Instead, the issue is to be resolved by deciding which are the most important policies for determining the application, and then concluding whether as a whole they are up to or out of date. And I've given the reference to Wavenden there, but of course you can see in 11D itself that it refers to policies plural. Now that exercise is certainly not as easy as it sounds. There's an example of a relatively recent case, 2019, I think, where the sort of policies I have in mind were considered. The case related to the former St. Albans school in Rottingdean. HE3 and HE6 of the Brighton and Hove local plan were relevant, listed buildings and conservation areas respectively. They were drafted in what I've described as absolute terms. And what I mean by that is that they both said development will not be permitted where it would have, and in one case an adverse impact, in another is likely to have an adverse impact. So you can see that within their terms they didn't contain a balancing element. Now you will, or you may appreciate that in national guidance on the paragraph 196 of the framework, it is explained that heritage benefits are intended to be capable of inclusion within the term public benefits. And heritage benefits will include the making of changes which will sustain or enhance significance. The approach taken in the High Court, a decision of Sir Duncan Ouseley, led to the conclusion that the policy required an overall judgment about harms and benefits, and therefore that there wouldn't be no conflict with policy even where there was even when some element of harm arose, if that harm was outweighed by beneficial effects. So just analysing the points for a moment, a policy drafted in absolute terms can be argued that it's out of date as a result of the formulation of the framework, that balancing component. Well, in Safe Rottingdean, the court was prepared to infer that in the officer report a balance had been undertaken within policy, and as a result the decision was lawful. Might it be analysed differently? Well, in Peel, the Court of Appeal decision in Peel from last year, I take from that it is lawful to treat as up to date and to give weight to policies which continue to be effective in delivering their original objectives. So one can understand why in the context of a heritage policy, albeit drafted in absolute terms, that it might be effective in delivering the policy objective, which is the conservation of the historic environment, whether listed buildings, conservation areas, or otherwise. And you could argue that you could give weight to that original objective. What about 213 of the framework, employing as it does a sort of sliding scale metaphor, from the greatest weight to be given to policy when it's consistent with the national planning policy framework, through to reduced weight depending on the extent of inconsistency? Might it fall off the edge if it's wholly inconsistent and become out of date? So that's a different policy-based way of looking at the matter. But finally, in thinking of this sort of formulation of heritage policies and in challenging all of that sort of reasoning, an alternative way of analysing this is to say, well, such policies need to be understood in the statutory context of decision making. So Section 70 of the 1990 Act, Section 38(6) of the 2004 Act. So in accordance with the plan unless material considerations indicate otherwise. And that, of course, provides an even wider balancing component. So therefore, we might say it's unproblematic in principle for policies not to contain a balance within their own terms. I'm not going to resolve this matter with you now. It was in fact the subject of argument in Bramshill. A decision is awaited on that from the Court of Appeal, Bramshill being a quite exceptional mansion with its own designed parkland over in Hampshire. So finally, we then turn to the third item on my agenda, at least, in Guilford case, which related to a development at Ash Manor in Ash Green in Surrey. It is salutary because it serves to emphasise that the court will in fact apply quite exacting standards to an officer report in this context, recommending the grant of planning permission. Now, in that case, the officer report did set out the Section 66 statutory duty, and you might think that that's a very good start. However, it didn't advise members about the weight to give to harms to heritage assets. In particular, there was a failure to explain that a finding of harm is a matter to which the decision maker must give considerable importance and weight in the planning balance, as you know, Barnwell Manor. The officer report, in addition, failed to refer at all to paragraphs 193 and 194. You may remember that the predecessor paragraphs in the PPF were described by Lord Justice Sales in the Jones and Morgie case as a fasciculus of paragraphs denoting a bundle. In anatomical terms, you might say a bundle of interconnected nerves. Those being connected need to be considered in order in their terms and applied in accordance with their terms. What Lord Justice Sales also said was where there was reference to one of those paragraphs, the court would be prepared to infer that the others had properly been taken into account, absent some indication to the contrary. But in the instant case in Guilford, the court accepted that there were indications to the contrary, so no reference to 193 or 194, as I understand it, and indications that in fact they had not been taken into account. It seemed to me, reading the judgment, that what was particularly damning for the officer's report was that there was a previous report which had recommended refusal of planning permission, and that seemed to have dealt much more fully with the statutory test and national policy relating to it. Sticking with the theme of tilted balances, of course, the heritage balance too mustn't be treated as if it were a straight one. Section 66 is placing considerable importance and weight on one side, the harm side, tilting the balance away from granting planning permission in those circumstances. It's not determinative, of course, but to borrow a phrase from Forge Fields, it gives rise to a strong presumption against planning permission being granted. And that must be reflected in advice to members, and courts are prepared to quash if it's not, and the Guilford case is a good illustration of that. So how did you get on with the quiz? I've got the answers up here. The odd one out, that was A, Longdean House in Hazelmere, because according to the Farnham Herald, there was quite a battle to try and get it listed, which failed. And so therefore it's not on the statutory list, and that was the exception. In order of importance, using the HE listing descriptions, listing categorizations and descriptions final on this matter, Bram's Hill Mansion, of course it's registered parking garden 2, grade 1, Dissay the RPG. D was next, Ash Manor, that's grade 2 star. C is the former Albans school, that's grade 2. And then last but I'm afraid least, Longdean House, not listed. And in terms of the era within which they were constructed, well, Longdean is late Victorian. Bram's Hill is Jacobean, as is its designed parkland. St Albans, I understand to be late Georgian. I think it was opened in 1832. And Ash Manor is a medieval manor moat house with later additions. I believe it's the main building is now divided into 2 dwellings, but it sounds absolutely wonderful. And I may have thrown you off the scent a little bit by only providing you a watercolor of it. But anyway, I hope you got all those right. I'm going to inspect the questions and answers to see if you did. Right, I'm going to stop sharing there. So we should come back onto here. I'll see. Thank you, Craig. I'm going to hand over to you now.
Thank you very much. Thanks, Melissa. I hope I can be heard and seen, and I'm sure I'll be told quickly if I can't. Thanks again to Melissa for a very stimulating presentation, a lot of moving parts, and we envisage more change to the law as time moves on, and in particular we look forward to the decision on the Bram's Hill case, and Melissa is very well placed to speak to that. She was involved in it. So I'm just going to try and share my screen. And again, I'll be told where I haven't managed to achieve that. I hope my screen and the slides can be seen. So the news so far in 2021. I'm going to divide my slides into 3. First, I'm going to look at the case of Klin against Water Lily in the Court of Appeal. And then I'm going to look to the draft revisions to the framework and associated consultation documents. And then I'm going to turn to the ministerial statement on historic statues, plaques, memorials, and monuments. In turn, that is the news so far in 2021. So first, a very interesting case, Klin against Water Lily in the Court of Appeal, related to a property or 2 properties in Palace Gardens Terrace, which is a very smart and very beautiful street, as you can see, in London W8, just to the west of Hyde Park and to the south of Notting Hill Gate. And at a stroke, you readily appreciate that if you had lucky ownership of one of the houses in this street, understandably, you might feel, well, one might not be enough, especially in lockdown, that you might want to have 2. You might want to knock from one into your neighbours if you own that property as well. And this was the case in Klin, albeit not in lockdown. Mr. Klin owned number 48, and he also came to own number 50, 2 substantial properties, but neither was big enough for him. And so he asked Water Lily to be his contractor in order to, in effect, make 2 properties into 1. The project was a very significant one, carrying out demolition, refurbishment and reconstruction works to form a single property. What that meant, in very brief summary, was the removal of the entire interior including the party wall between 48 and 50, leaving the party walls to 46 and 52, much of the front elevation and some of the rear elevation. And so work began some while ago now in March 2013, but stopped in August when Kensington and Chelsea, the planning authority, said that conservation area consent was required and had not been obtained. So Mr. Klin went and obtained conservation area consent and work resumed, but a year later. And the dispute was a contractual one over the responsibility for the delay. The issue was this. There had already been previous litigation which had concluded that there was an implied term in the contract that Mr. Klin would use all diligence to obtain the relevant permissions. So the issue for the Court of Appeal was whether or not conservation area consent was lawfully required for the demolition works. Specifically, what is the correct approach to take when determining when construction works should be treated as amounting to demolition for the purpose of Section 74 of the Listed Buildings Act. That question was going to require some consideration of the principles identified by the House of Lords in the case of Shimizu, which of course related to listed buildings. Just a reminder about Section 74, as it then existed prior to 2013, a building in a conservation area shall not be demolished without consent, referred to as conservation area consent. And as you will know, the 2013 Act repealed Section 74, but it still applies in Wales. So we still need to understand its interpretation and its operation. And so far as England was concerned, there was to be a new requirement for what became known as demolition planning permission. Demolition included within the definition of building operations in Section 55, but the new provision was Section 196D of the 1990 Act, creating an offence for a person to carry out or cause or permit to be carried out relevant demolition without planning permission. And relevant demolition meant the demolition of a building that is situated in a conservation area. So that sets the scene, but it's also worth bearing in mind that Klin on its facts depended upon the original Section 74, but now that Section 74 for England has been repealed, it doesn't follow from that that this case is of no interest for reasons that will become clear, not least because the word demolition is still retained in the English legislation relating to demolition and the requirement for planning permission for demolition in conservation areas. Now, Mr. Klin argued, I've set them out there. There are two main reasons. I mean, first, he said, well, where a substantial part of the building remained intact, then consideration of the impact on the conservation area might be highly relevant. And of course, he was going to argue that, wasn't he? Because he had kept some of the front and some of the back. He gave two reasons for that. First, Mr. Klin argued that the purpose of the legislative conservation area scheme to preserve the character or appearance of conservation areas is relevant. And what it meant was, having regard to Shimizu, is that in a situation where at least there should be a partly qualitative exercise of judgment, bearing in mind the purpose of the conservation area legislative scheme, and not just a purely quantitative exercise. It might be highly relevant, it was argued, for example, whether the demolition proposed would be capable of having a significant adverse impact on the character of the conservation area in question. The second point that was made was directly relying on Section 72 of the Listed Building and Conservation Areas Act, which of course expressly requires that when exercising any function under any of the provisions of the Planning Act, special attention has to be paid to the desirability of preserving or enhancing the character or appearance of the conservation area in question. And it was said that Section 72 extends to the function of making a determination that conservation area consent is or isn't required, which is a separate and discrete function from the separate and subsequent exercise of deciding whether to grant conservation area consent. Reference was made in argument by Mr. Klin to the case of Shimizu, which of course focused on listed buildings, but also included observations in relation to Section 74 and the position in relation to unlisted buildings in conservation areas. And Mr. Klin said, well, you don't need to worry about those too much because they were obiter, and that the finding in Shimizu, the central finding, the ratio, as it was argued, doesn't affect or detract from the strength of the argument that he presented. Now, pausing there, one can immediately see, I hope, that the arguments that Mr. Klin deployed, whilst they were raised in the context of Section 74 as it then existed, one would still be capable of being raised in Wales now. Two, that in any event, by reference to English legislation and demolition planning permission being required, it would be arguably possible to extend the arguments to the requirement for planning permission by reference to Section 55 and Section 196D of the Planning Act. Now, Lady Justice Carr rejected the argument, and she did so for 5 main reasons. The first, having looked closely at Section 74 and recognised that there were indeed 2 parts to it. First, whether what was being proposed was actually demolition, and if it was, the second question, whether or not consent was required. She came to the conclusion that, notwithstanding those 2 questions, the planning authority is performing a single function. In other words, controlling the demolition of buildings in conservation areas. Section 72 is for the second question only, and Parliament, she said, was unlikely to have intended the matters identified in Section 72 to be considered twice. The concept in Section 72 of paying special attention to the desirability of preserving the character of a conservation area, she said, is simply not apt in the context of what is a fact-finding exercise in terms of whether or not a building is being demolished. It involves questions which go well beyond simple questions of fact and degree. And she said it would be wholly unrealistic to place on developers the burdens of assessing the impact on proposed works on the character or appearance of a conservation area in order to identify whether or not conservation area consent was required. That qualitative assessment, she said, was a matter for the planning authority, not for the applicant or for the developer. Now, in relation to the Shimizu case, she confirmed that the question of demolition is a question of fact and degree to be assessed on a quantitative basis only. There's no suggestion, she said, in that case, of there being any qualitative exercise to be carried out. It would apply to Section 74 and demolition in a conservation area, just as it does to the listed building regime, irrespective of whether Lord Hope's observations were obiter. Now, one can again say, This case is relevant to existing legislation in Wales, but it's also pertinent to the possibility that perhaps it existed before this case of similar arguments being raised in the context of demolition planning permission. So I turn now to look to the second part of my presentation, draft revisions to national policy and guidance. And there's quite a lot happening at the moment. First, there are draft revisions to the framework, and the period for consultation for these documents is the end of January to pretty much the end of March. So far as the framework is concerned, the text has been revised to implement policy changes in response to the Living with Beauty report, and changes are made throughout the document, not just to that, to reflect that report, but others too. But in a design and heritage context, it's the Living with Beauty report that I'm just highlighting today. Paragraph 8C, recall that's one of the overarching objectives of sustainable development, the one that relates to the environment. That's been strengthened to emphasize the role of planning in protecting and enhancing the historic environment by a simple deletion of the words contribute to. So instead of the role of planning contributing to protecting and enhancing the historic environment, the words contribute to have been deleted. So the role of planning to protect and enhance the historic environment. There's a change to the design chapter of relevance. Paragraph 127, all local planning authorities should prepare design guides or codes consistent with the principles set out in the National Design Guide and the National Model Design Guide, and which reflect local character and design preferences. Elsewhere, changes to the framework say that these guides and codes should be brought forward in local plans or in supplementary planning documents. Paragraph 197 in chapter 16 is new, and it says this: in considering any applications to remove or alter a historic statue, plaque, or memorial, whether listed or not, local planning authorities should have regard to the importance of retaining these heritage assets and, where appropriate, of explaining their historic and social context rather than removal, what has in short been called the policy of retain and explain. Just pausing there, with current government in place and the inclination it has to adopting three words when it wants to get a message out, A, B, or C, I'm surprised that retain and explain is a simple two-word phrase. They could have said retain, refrain, and explain. Anyway, retain and explain is nonetheless memorable and shouldn't be distracting. Now, the National Design Guide 2021 was published in October 2019, some time ago, and I won't take time by reminding you of the content of the document and the 10 characteristics said to contribute to the cross-cutting themes for good design in the framework. And you will already have seen that in that document, there is some mention of history and heritage and the significance and setting of heritage assets. But it's mainly more general in terms of the scope of design in development control. But the document has now been updated so that it aligns with the National Model Design Code and the guidance notes for design codes. So we need to look to the draft National Model Design Code. The purpose of this document is said to be to provide detailed guidance on the production of design guides and codes and policies for the promotion of successful design. And it is based upon the 10 characteristics from the design guide. And the objective is plainly to give guidance to local planning authorities so that there's consistency in the guides and the codes that in terms of their approach. The document sets out clear design parameters to help authorities and communities decide what good quality design looks like in the area based on local aspirations and with the benefit of consultation. So those are the sort of three main objectives, if you like. What it does in some detail is provide a 7-step coding process, which does require a bit of a cold towel exercise to fully absorb. The three overarching words are analysis, vision, and code, but each one of those is broken down so it results in a 7-step coding process. You need to look at it and you need to examine it to see how it affects your particular practice or expertise. And bearing in mind that the consultation period is still running, you may feel that you want to make representations. You may, for example, consider that it provides a somewhat mechanistic approach in its coding process, or that it provides far too much detail, which might have an adverse effect in terms of constraints on appropriate development. You may also think, well, does it say enough on heritage? It doesn't say much in express terms on heritage. You may think that there ought to be more cross-reference to historic England's guidance. Now, similar comments can be made in relation to the draft guidance notes for design codes, which sets out the possible contents for a design code, again, based on the 10 characteristics. So we've got these three for the National Design Guide at the top, and then we've got these other two documents, which are very detailed and provide a lot of content. So far as heritage is concerned, again, not numerous express references, but I've selected one where the document says that development should always take account of heritage assets within or close to the site as defined by the framework. The character and distinctiveness of a place is created by the richness of the buildings that have been built up over time. And then there's reference to how buildings relate to each other and contribution to the evolution of the place as a whole. The presence of historic character should always be seen as an opportunity to add value to any development by helping to provide inspiration. Again, the document requires some detailed reading, and if it stays in the form that it is, local planning officers and designers acting for developers and advising them will have to put in some considerable time to see that each and every part of these guidance notes have been taken into account and applied where appropriate. Again, you may feel when looking at it that it is a somewhat mechanistic approach with too much constraining detail. You may also think that there's not enough guidance on heritage issues and how, in the context of the design of a scheme, those issues should be resolved. I turn lastly to the written ministerial statement on historic statues, and you'll recall that this arose out of the famous Colston statue being pulled over, and Mr. Jenrick, amongst others, I'm sure were incensed by what had taken place, and the government, reflecting that concern, has, through this statement, set out its intent. Mr. Jenrick intends to make removal of any historic unlisted statue, I beg your pardon, subject to an explicit requirement to obtain planning permission, even though it's unlisted, and to require local planning authorities to adhere to a similar notification requirement as if for listed building consent applications. Now, you will immediately see that to achieve that not only requires changes to legislation, but also some considerable thought about how that's going to work in practice when one's dealing with unlisted statues, plaques, or monuments. It seems to me that that is going to put another substantial burden on the shoulders of planning officers at a time when, leaving aside COVID, resources and time are constrained. There's also an intention that in considering any proposals for removal of a listed building or an unlisted building, authorities must have regard to the written ministerial statement in September last year, that is, in short, to retain and explain the government's policy there, to retain and explain. And that's now to be treated as policy, reflected in the new draft paragraph 6 of the draft revised framework. There's also reference in the statement to Historic England's stance, which is the same, to retain and explain, and to provide thoughtful, long-lasting and powerful reinterpretation that responds to their contested history and tells the full story. So that's all the news for now. Thank you very much for tuning in. I'm going to stop sharing. And return to the screen. And there are a few minutes, so if there are any questions, we'd be happy to seek to answer them. I'm going to ask Melissa whether there are any questions that she's seen which affect or relate more to her presentation than to mine.
Thank you, Craig. No, within the chat, participants have very kindly told us when we can be seen and heard, which was really sweet. Also, thank
now I've lost contact with Melissa.
Thank you very much. The only can I be heard now?
Yes, I can. Thanks, Melissa. Thanks.
Excellent. The only question that we have, I think, Craig, outstanding is, what age would a historic unlisted statue have to be in order to benefit from the retention explanation type approach that the government envisages? Or haven't we got down to detail on that yet?
That's a question from Elizabeth Martin. I see that. Yeah. And I think, in short, I'm not going to pretend I know the answer to that, but it just may be, certainly in the documents that I've read to compile the slides, I've not found any clue to that. Whether there is some reference to age in one of Historic England's documents may be a different question. I think I'd need some time for that, but certainly that will be a matter that will have to be covered if the government keeps to its specified intention of referring now to what are called historic unlisted buildings. I appreciate that's one of the great problems, great difficulties that are going to have to be addressed. Elizabeth has suggested 1948. Well, I can see some force in that. One, because it's a fixed date, and two, it's a date that is used already in listed building legislation, and of course would therefore align with the listed building provisions. And but beyond that, I can't say how the intention is going to evolve to answer that question in clear and reliable terms. I'm just seeing whether there are any other questions. Well, I'd like to think that if there's any one question, that means that what we've said, Melissa, is clear and I hope helpful. And I'm very grateful that so many of you listened, and we will be able to provide the slides as soon as we can. Melissa, do you have anything to add?
No, thank you very much indeed, Craig, and thanks to all of you for coming to join us this afternoon.
Good. Thanks, everybody, and have a good remainder of the day.